Hi everyone, my name is Robert Foho. I am an attorney and I am based in New Hampshire and Massachusetts. I practice in both of those states as well in Florida. I wanted to take this opportunity to discuss and explain why I believe the Massachusetts Department of Elementary and Secondary Education's statewide mask mandate, which went into effect last week, is illegal. And I want to explain in detail why I believe it's illegal. So this all started a little over a week ago. The department, or DESE as many people call them, it's also known as the Board of Elementary and Secondary Education, issued a press release in which it explained that Education Commissioner Jeffrey Riley would ask the board to grant him the authority to mandate masks for all public K-12 students and educators and staff through October 1st. And then they went ahead and did that early last week on Tuesday. And then, as we all know, the mandate was announced on Wednesday. Now, in order to understand what's going on here, okay, you need to understand some basic principles about administrative law and how these agencies, like the Board of Education, the Board of Elementary and Secondary Education, and other agencies, are created and what they can and cannot do. All right. Now, generally speaking, if you go back all the way to the very elementary principle that we are all born with certain natural or God-given rights, however you like to describe them, and then we give up some of those rights to government in order for the government to protect us. The government only has those rights that we give them. In other words, the government only has those powers that we give them. We create all of these different institutions. We created an executive branch, we created a legislative branch, we created a judiciary. Those different branches only have the rights and powers that we give up to them. Now, in creating these different institutions, the legislature in every one of these states and at the federal level, they often delegate certain responsibilities and powers to administrative agencies. Now, there's a whole debate about whether or not administrative agencies are constitutional because they often blend all powers from all three branches of government into one administrative agency, but that's a discussion for another day. But the legislature will often delegate responsibilities and powers to these agencies, and these agencies are often confined to a specific industry. So, for example, there may be a liquor commission that's created in every state to address and regulate the issuance of liquor licenses and the sale of alcoholic beverages by not only retail shops but restaurants and bars and such. And so those agencies are given certain powers and certain duties, and their powers are confined to whatever the legislature has delegated to them. So the Massachusetts Supreme Court, as well as the courts in many other states, have always held that an agency's power to make regulations is delegated to them by the legislature. They don't just come up with these powers out of thin air. Whatever they have is what the legislature gave them, which in turn is what we gave the legislature. So, stemming from that principle, logic would dictate that an administrative agency has only those powers and duties and obligations that are expressly conferred on it by statute or reasonably necessary to carry out the purposes for which it was established. In other words, the Department of Elementary and Secondary Education has only the powers and duties that were given to it by the legislature, or that are reasonably necessary to carry out what its purpose is. What does that mean? Well, that means that you can actually go and look at a statute and find out what powers an agency has and determine whether or not the agency has the authority to carry out a certain action that it has undertaken. So, logic would thus dictate that if an agency carries out some action that it has no authority to promulgate, then it's invalid. And again, the court is also held, like the courts in many other states, that an administrative board, an agency, or an administrative officer has no authority to make rules or regulations that are not only in conflict with statutes, which either created it or other statutes, or that exceed the authority conferred on them by the statutes by which they were created. So let's look at a specific example. In one of the cases I just mentioned, the Commissioner of Insurance in Massachusetts issued regulations that prohibited life insurers from considering gender-based mortality differences in the underwriting of life insurance. That he was sued for doing that because it was outside the scope of his authority. The Massachusetts Supreme Court held that he was not authorized to promulgate those types of rules because he didn't have those powers, so he couldn't undertake something he did not have the power to do. All right. Now, let's look at the powers of the Board of Secondary and the Board of Elementary and Secondary Education's powers in the statutes that govern it. Okay. Massachusetts General Laws, Chapter 69, Section 1B, identifies many of the powers that the board has been given. All right, and they range from things like establishing policies concerning the education of students in public early childhood, elementary, secondary, and vocational technical schools. That's one of its broad powers. It also has the power to establish standards for certifying teachers, principals, and administrators. It has the power to promote the implementation of participatory management systems, and I'm just going through a lot of the powers that it has in Section 1B. It has the power to establish the process and standards for school and district audits and reviews, and this all makes sense for it to have these types of powers because it is, after all, tasked with governing and regulating the education industry in the state. It has the power to provide technical assistance, curriculum, materials, consultants, support services, and so on and so forth, and those types of services for school districts, and to encourage programs for gifted and talented students. It has the power to publish profiles for each school and school district in the Commonwealth. It has the power to withhold state and federal funds from school committees in various instances. And it has to see to it that all school committees comply with all laws relating to the operation of the public schools. It can establish the standards for the recognition of high achievement by students and school districts. It can establish criteria to define areas with a high number of low-income children for purposes of the school breakfast program. These are very, very specific powers. And this is all by design. You can't just grant an administrative agency the power to regulate education in the state. Well, how does it know what it can do or can't do? Because they only have the powers that we give them. So it needs to know what it can and cannot do. And that's why many of these powers in the statute are specifically defined and explained. For example, the board can encourage collaboration between local school districts and vocational technical school districts and regional employment boards. It can establish maximum pupil-teacher ratios. This is as specific and as fine-tuned as it gets. And then here's one that's relevant because this is what's cited in the mass mandate. The board shall establish minimum standards for all public early childhood, elementary, secondary, and vocational technical school buildings, subject to the provisions of the state building code. The next sentence, this is all separated in a single paragraph in Section 1B. The board shall establish standards to ensure that every student shall attend classes in a safe environment. What does this section mean to you? Well, it obviously means that the board has the responsibility to make sure students are attending school in buildings that are not going to crumble, buildings that are up to code, buildings that don't have asbestos in them, and so on and so forth. So keep this in mind, dock it in your brain, because we're going to come right back to it. Then there's a catch-all provision at the end that says that the board can establish such other policies as it deems necessary to fulfill the purposes of this chapter, and it cites other sections in the statute in that chapter, none of which have to do with passing health measures or anything like that. Section 1G in the same chapter also says that the board can establish the minimum length for a school day and the minimum number of days in the school year. So these are low threshold standards for what constitutes a school year. Obviously, it has the responsibility to oversee that area as well. Now, when we go to the mandate that was issued on August 25th, after the commissioner obtained the authority he needed from the board, people are very focused on what the mandate says. I am more interested in what authority the mandate cites for issuing this kind of requirement. In the very first paragraph, the mandate states that the board voted to declare exigent circumstances pursuant to the student learning time regulations, and it provides a citation to a rule number, that's 603 CMR 27.08. Okay, now let's go there. If you've never heard of these before, you can Google them very easily. I've included the URL at the bottom. This is a set of rules promulgated by the board, okay, that concern the titled student learning time. All right. So upon first glance, this should indicate that these rules govern how much time kids are supposed to be in school, how many hours per day, how many months out of the year, so on and so forth. All right, now, the reason I'm looking at this again is because this is what the mandate cites as the authority for issuing a mask mandate. The purpose, now this is very important. The purpose of these rules, if you go to the very first section, it's titled Authority, Scope, and Purpose, and then section 1, it goes on to cite section 1G, which I cited earlier. That's a section that governs how much time kids are supposed to be in school. And this is one of the sections that is cited as the reason for why this set of rules, the SLT regulations, was created. But then it goes on to say that the secondary purpose for why these rules were created were pursuant to section 1B, which is what we looked at, that whole set of powers that I went through. Section 1B, and they refer to a very specific section in that I just reviewed with you. And that is, it requires the board to establish standards to ensure that every student shall attend classes in a safe environment. All right, but now they take that section and they expand it to include much more than what it was intended to include. And look what they've done here. In section 2, the purposes of 603 CMR 27 are, number 2, to establish health and safety standards for schools during a declared state of emergency or other exigent circumstances that adversely affect the safe environment of schools as determined by the board. Where did the word health come from? They literally just inserted the word health along with safety to give them the authority to pass health measures. So what was initially an obligation and a power to provide a safe environment for students in safe buildings that are up to code, and so on and so forth, they have now expanded that power to include passing health measures. That they had no authority to do this. So they created this rule to include health measures, and then now remember, they cite 603 CMR 27081 in the mandate. Now, if you go to section 8 of the student learning time regulations, this is where the phrase exigent circumstances comes into play, because it gives them the option either to rely on a state of emergency declaration by the governor or a determination by the board that exigent circumstances exist. In that scenario, the commissioner then shall issue health and safety requirements and health and related guidance for districts. So they don't even need an emergency declaration by the governor. All they need is a determination of exigent circumstances, and then under this newly expanded power, under these rules, they can then issue health guidance such as mask mandates, and that's precisely what they've done. They cited 603 CMR 2708 section 1, which I was just looking at, and then the commissioner essentially parrots language from that section, consistent with the authority provided by the board, and after consulting with medical experts and state health officials, the commissioner is implementing the following requirements, and they go on to explain all the detail with the mask mandate. On the bottom of page 1 of the mandate, they, in a footnote, they include, again, purportedly what their authority is to issue this mask mandate. They cite 1B, as I mentioned, which is the safe environment language that I referenced. They cite 1G, which, again, has nothing to do with health measures. That has to do with student learning time in school. And then they cite these other sections that, in Chapter 71, which we looked at in my recitation of the various powers that the board has. None of those have anything to do with health measures. All right? And then, of course, they rely on 603 CMR 27.08, which is the procedural mechanism for issuing this mandate, but doesn't confer any substantive authority for issuing a mask mandate. So, and then they go on to implement the requirements of that student learning time regulation, which is consistent with the requirements in the mandate, the substantive requirements that the commissioners provided. School districts now have to submit a plan confirming that their health and safety procedures are going to be consistent with these requirements. So the conclusion, the bottom line is the board lacked the authority to issue this mandate for K through 12 schools in Massachusetts Nothing in the statute confers it any authority to issue health measures like this. They have intentionally expanded that section of Section 1B to confer on it the authority to not only to provide a safe learning environment, but also to pass health measures, which is seemingly broad enough here to include the issuance of a mask mandate for all schools in Massachusetts. That is invalid. It's illegal. They lack the authority to do that, and the way to challenge that, unfortunately, is through court action. So if you have any questions or concerns, this is my contact information. Thank you for your time and for watching this video.